Good afternoon. Okay, let's go over what's going to happen at your ALJ hearing. I know it's very stressful and nerve-wracking. You might be having your hearing by video with MS Teams, or it might be on the phone as a phone hearing, or an in-person hearing. The video hearings are very, very popular right now. Obviously, they came about as a result of COVID. Um, and very surprising to me, I will eat crow. I didn't think I would appreciate it, but I do. There's a variety of reasons that I'm not going to go into here, but I found that the video hearing system that's going on is working really well for claimants, and probably for everybody concerned, for a variety of reasons. But it's a really, really, really surprising, helpful thing for a lot of people, and in particular claimants. Okay, so regardless of which method you are going to be attending your hearing in, let's go over the basic structure of the hearing. I won't go into details and the nitty gritty on each one. We could do that in a different video, but just so you know how it's going to generally be laid out. So however you're getting into your hearing, when you're in there, it's going to be you and the judge. If you have a lawyer or a non-attorney rep, they should be there with you. And there's a person, I think they still refer to them as a court reporter. She's recording the hearing. So keep in mind, even if you're on video hearing, it is not going to be video recorded. It is only audio recorded. And that is for keeping it in the record so that if there's an appeal, the entity that will be reviewing the appeal can listen to the recording and see what happened at hearing. Okay. So that just brings up the fact that whenever you're communicating with the judge, you will be speaking, not nodding your head. Or if you're nodding your head, be sure that you're vocalizing your answer as well. And he or she's probably going to remind you of that. But anyway, so the only other person that might be in the room is a vocational expert if you're in person. If you are not in person, most often the vocational expert, which is brought in by the SSA, is going to be on the phone. I don't really see them in the hearing on video like the rest of us are. So they'll probably just be called in by phone, and they will be listening generally to the entire hearing. If there is a medical expert, and this is much rarer as far as I'm concerned, almost always is a vocational expert, but on occasion there's a medical expert. He too would probably be present in the same manner as a vocational expert, in person or by phone. In person if it's an in-person hearing, or by phone if it's an in-person hearing or a video hearing. Okay. The judge is going to, once everyone is there, swear you in. He's going to swear you in and the only other witness, presumably, which would be that vocational expert or a medical expert. In the more unusual instance where you asked if you could bring your own witness, that could be a family member or somebody who knows you well. He would ultimately have to be sworn in also, but usually that would come later because they're generally not, historically anyway, any witness you were going to bring, that I guess you're going to ask questions of, that person is not going to be in the room with you when you're testifying, usually. So all the swearing in is going to go on. Your lawyer, if you have one, or your non-attorney rep, is not going to be sworn in because we are not witnesses. We are the lawyer or the representative. What our role is to obviously take good notes. And then we often do the direct examination of you. The judge might do the direct examination of you. That's very common, but then he's always going to open it up for us to continue it for anything that we know that we want to bring out that he wasn't aware of or didn't ask. So everything that we want out there is out there. The judge will also direct examine the vocational expert, and then we can cross-examine the vocational expert with additional questions. That's the terminology I would use for that. And by and large, there's always going to be questions that the lawyer or the rep is going to ask of the vocational expert. Okay, so sworn in, everyone's settled. The basic areas that the judge is going to cover. This is for a standard case. There can be issues separate and aside in the more rare instances, and then you'll have to address them kind of ad hoc. When you've gotten your hearing notice, it should tell you what the issues are. And generally that's were you insured if it's a Title II claim? And when is your date last insured? And is there a finding that you did indeed become disabled during that period up through the date last insured, if that date last insured is to the past? If there are other issues, they'll be noted in there. So by and large, if that's the case, if it's your standard run-of-the-mill hearing, the first area the judge is going to inquire about is your prior work. He's going to go through all of the jobs. This is what he's typically going to do. All of the jobs that are in your detailed earnings record, which is found in your file, your Social Security disability file, the official hearing file. So you should have a copy of that. They would mail you a CD generally if you're pro se. If not, your representative, in all likelihood, if they actually practice a lot, will be able to access it from the Electronic Records Express. So that's one thing we always pull down from there is the detailed earnings statement, because we need to go over all the jobs in the last 15 years. The last 15 years are going to house all of the past relevant work, and that's a term of art, that the judge is going to have to go through and quantify and qualify what your duties were so that you were skilled enough to do them. And because one of the later questions that he will be answering when he makes his decision is whether you can still do any of those prior jobs. Jobs from 20 years ago don't count. Only the ones that you did 15 years, up to 15 years prior. That all comes out through also on your work history report. So between the work history report and the detailed earnings report, that's where all the questions are going to be involving. Now, oftentimes there has been enough information and the detailed earnings report coincides with your work history report. So the judge doesn't really need a lot of extra questions, and he'll just kind of crash through that because it's been pretty clear. And hopefully you've made it clear and it's to your benefit and not clear to him in a way that isn't to your benefit. Depending if you made errors on your work history report. We're going to be coming out with some videos on the work history report because it is critical, particularly for the over 50 crowd. Okay, so they're going to go through the past work, every single job, make sure that he's got it clear what you did, make sure that his records are clear, and there's no missing jobs that he has to figure out what you did. After that, he's going to go through now the disability, your symptoms, the nature of your limitations, your pain. If there's mental health components to your claim, he's going to go through some of that as well. He needs to find out what your functional limitations are. And he's going to be comparing what you say with what's in your medical records, because remember, the medical records are the foundation. Your hearing testimony is not the foundation, but it can certainly be the frosting on the cake. So you want to make sure you've got it right and you know what your responses are to the questions that will likely be asked. So one way I think to prepare for that, as he's talking about symptoms and asking about your activities, he'll throw out questions like, do you shop at the grocery store? I mean, it could be questions like that. Have you been on vacation lately? What chores can you do in your home? And you're going to respond to those questions. And ideally, those answers are going to coincide with your medical records. Hopefully your medical records, not they talk, your doctors don't typically talk about how much you clean your house, but there should maybe be some discussion about any functional limitations you have. Hopefully you've shared them with your doctor. If you haven't, then you've kind of failed yourself on this one, but because we always need it to be found in the medical records. And then your testimony is clinching it and giving more color to it and more meat to it, more details. So one way you can prepare for that in a nutshell is going through the function report that you submitted earlier on. Hopefully you did a good job on that. We have a whole playlist and it goes by number. Function report, question number 5, number 6, number 7, number 10, number 20. So each video is just about the one question. I would really urge you, or if you're going to be doing another function report before your hearing, or if you have to apply again, unfortunately, I hope you don't have to, go through those and give a lot of thought to each question, because that function report is really important at the hearing. When you testify to something, and if it is inconsistent with what you said in your function report, it's either going to be that something changed, which people do. I mean, your functioning could have gotten better or could have gotten worse. You could have improved. That would be not so good for your case. Or you could have gotten worse. But you need to know so you can address it and bring it up and clarify it for the judge. So knowing what your answers were then is important. It's also helpful to look at that function report to prepare for hearing, because those are the kind of questions that the judge is going to get to, because those are the ones that kind of give an illustration of what a person may or may not be able to do. So that's probably where the questions are going to be derived that he is asking. So you can use it as a study guide and see what you said before and what you're saying now. It might have gotten worse. And if you did screw up your prior function report because you didn't have any guidance, nobody helped you, and you didn't have these videos that we have in the function report playlist we have, I'll link it at the end of this. You can clarify. I mean, if you have to do some damage control at the hearing, you might have to do that. You could say, if he asks you a question and you answer, and you know that your answer on your function report was different and was not helpful, you can explain, why your answer is different now. It might be that you've just gotten worse and it wasn't a problem then, or I didn't understand the question, Judge, back then. I've since learned a little bit more about it, and I wasn't thinking about my elbow limitations when I answered that question on reaching or whatever. So use those tools. Go through your work history report. If you have the official file, go through your detailed earnings report so that you know what the judge is going to have in front of him in terms of your past work, and you can get to it and make sure that you can explain each of those jobs. It can be tricky on the detailed earnings report because sometimes the corporate name is what's up there because that's how it was paid through payroll. So it's not going to say John Bob's fish fry that you worked at. It might say blah, blah, blah corporation, if it was owned by a S Corp or a LLC or, whatever, it could have a totally different name. So you're just going to want to make sure that you're familiar with what they are, and you can explain to the judge, oh, that was the fish fry I worked for. They just have that weird name. That's how our checks came. All right. So after you've done all that explaining and answering questions about your day-to-day activity, what you can't do during the day, and remember, you're going to focus on what you can't do and what you can't do normally, what takes you longer, what isn't done right, what maybe you have to do, spread it over a week instead of doing it in a half hour like you used to be able to do around the home. Then he's going to throw it onto the vocational expert, and he's going to ask the vocational expert a series of hypothetical people that are not you at this point in time, because he hasn't decided which one you fit best with. And the vocational expert will first quantify your prior work. That's why all those work history questions are important. And then decide whether the hypothetical person can do any of your prior jobs that are relevant, meaning in the last 15 years. And if not, can he or she do any other work that exists in substantial numbers in the economy? And to do that, the vocational expert will spit out, if there are any, to the hypothetical that is posed by the judge. He will spit out those jobs, the title, the DOT numbers for identification purposes. What's the exertional requirement for that? What is the SVP level of that, skills and all that? And those are the jobs that that hypothetical person is able to do. So if the judge decides that you are that hypothetical person, that you match up to him, you don't have additional limitations that would prevent you from being that hypothetical person. If there are jobs, then you're looking at a loss. But usually they go on to a second hypothetical where they tighten up those restrictions and make it a more limited person. If the judge doesn't do that, you're going to want to throw additional hypotheticals to the vocational expert. So be prepared to do that. If you listened and you saw that the judge didn't include, the fact that you can't use your right arm, find out if the jobs that the vocational expert presented for hypothetical number one would not be able to be done by a person who has an arm that they can't use more than occasionally, or they can't lift more than 3 pounds with that arm, or they can't, reach high with it or reach out in front for very long. That's a little bit of a skill. You may or may not have it if this is your one and only time, but you're going to want to get a hypothetical. If your judge is leaving it at a hypothetical 1 and there are jobs available, you're going to definitely want to present a hypothetical 2 if he doesn't, so that it eventually gets to no jobs. And then that gives your judge the opportunity to, this claimant really is more like hypothetical number 2 or 4 or whatever, where there were no jobs. But if you leave it at hypothetical number 1 and there were jobs, it's not going to be good. Okay, and that's a generality, by the way. So once they get through with whether there are jobs of the hypothetical person to do, the judge will thank the vocational expert for his time. He's going to thank you for your time, and he's going to probably say something to the effect that he's going to review the evidence, the file, review your testimony again, and make a determination, a decision, technically a decision, and he will get that written up and sent out. And then you'll have your answer, and he's going to probably try to be as quick as he can, but just know that sometimes it takes a few months. Sometimes it's shorter because there's more than just one person in control of that. I mean, so nobody has true control. The judge makes his decision, but then it has to go to decision writers to be written and then sent out. So it can be a little bit of a wait. I've seen it as fast as 2 weeks, rarely, and as long as 8 months, rarely. So expect it to be something in between, usually like 2 months, but that doesn't mean yours is going to be 2 months. Okay. All right. So I hope that gives you a quick summation of the hearing and what you can expect and a little bit on how to prepare. Okay. Good luck with your hearing. I hope it works out fantastic for you. Bye now.